Do we have everybody here that for the 2 o'clock?
I believe so, Your Honor.
Okay.
Yes, I believe so too.
One second. You're David Ortego?
Urtiago, Your Honor.
Tiago. You're for the plaintiff?
Yes.
We've got a summary. Do y'all need a record on the summary judgment?
Not on the summary judgment, Your Honor.
Okay.
Your Honor, if it's possible, if we do have a court reporter, I would ask for a record.
Okay. On the summary judgment?
Yes, I realize it should be based on the pleadings, but to the extent of the argument is going to be oral, I would like that to be memorialized in a record if possible.
Okay. We got Leslie here.
I'm here.
All right. We will go on the record in cause number D22881 CV, Ivy versus Atmos Energy. I have David Urtiago present for the plaintiff, Kevin McGuire is present for the defendant, and you may proceed.
Yes, Your Honor. If we may share the screen.
Yes, let me make sure it's turned up. Well, now it's on.
Your Honor, since this is our first time before you, if I may just take a couple of minutes to sort of describe the background of this case and why we're here before you today. And let me do that by going through a timeline of events for this. I represent Atmos Energy, which is the natural gas utility for this part of Texas. And Atmos Energy's predecessor in interest acquired an easement over a piece of property near Retreat in 1915. They installed a pipeline, which is referred to as Line M, on that property in approximately 1922. That pipeline was replaced in 1953 and extended. And then in 2005, Atmos Energy acquired the interests of TXU Energy and is now the owner and operator of that pipeline. The property in question that we're here for in this case was acquired by the plaintiff, Mr. Ivy, in 2010. And he purchased it from the city of Corsicana. It's 137 acres that he purchased for $144,000 in 2010. And at the time that line from 1953 had been was on the property and had been operating. In the fall of 2018 is where the project that gives rise to this suit began. And that in the late fall, early 2019, Atmos began to replace the original 10-inch Line M that was laid in 1953. And in order to do that, they placed a new 10-inch line in the ground and abandoned in place the 1953 line, or as we refer to it, the original Line M. So during the course of that replacement, if we can go to the next slide. So there's a couple things going on here as the court will pick up on. Number one, if on the left side of your screen, you see some old pipe that was temporarily placed on the Ivy property. That pipe is actually not an Atmos pipeline. That was a pipeline. We don't know whose it was. It was not registered with the Railroad Commission. We've been referring to it as a ghost pipe. But it was a pipe that Atmos encountered during this replacement project. And so in order to complete this project, they removed that pipe from a neighboring property owner. We're transporting it across the Ivy property. And the evidence will show that because of a rainstorm, they temporarily set it on his property. They claim it contaminated his property. We say we removed it and cleaned it up. That is another issue for another day. That is not the subject of this motion. The subject of this motion deals strictly with the abandoned line M. That was, again, originally laid in 1953, was replaced and properly abandoned in place in 2018, 2019. The plaintiff claims that after digging down into the easement, that they discovered some asbestos coated joint covering, which you see there on the far right side, of non-friable asbestos coated joint covering. It is this abandoned line M that is the subject of this motion. So on the left of your screen, Your Honor, and this is summary judgment evidence, but on the left of your screen is a plat of the property, and you can see on the right, far right side, east side of the property, we've got the railroad tracks, which form the property boundary, and then just inside of that, you'll see where it says Atmos pipeline markers. So of this 137-acre property, the Atmos pipeline, it's a blanket easement over the entire property, but the Atmos pipeline is on the very eastern property boundary. Now, when Mr. Ivy purchased this property in 2010, he did so with knowledge of that pipeline being in place. And the testimony from that, which is in the summary judgment record, is on the right side of your screen. He definitely knew that there were pipeline markers, that he saw it in his title commitment. He was well aware, as he says down at the bottom there, I was aware there was a pipeline. I assumed there was an easement. So he had knowledge of the pipeline when he purchased the property in 2010. And in his deed, he acquired the property as is, with all faults. And in doing so, he with knowledge of the property, that any damage to property that would have been caused by the original line M is a cause of action that does not run with the land. It did not transfer to the plaintiff. So as that applies to this case, plaintiff lacks standing to bring the following claims. Number one is, and Your Honor, I anticipate that what you're going to hear from the other side is, well, and as they say in their response, Atmos doesn't understand the nature of these claims. We fully understand the nature of what we see in the plaintiff's petition, and that is a breach of contract claim for refusing to pay plaintiff for damaging his land with the asbestos-coated pipeline. That's in the petition, paragraph 36C. We clearly see that they're claiming that failing to dig up the old asbestos-coated pipeline from within the plaintiff's soil in petition 43, section C and D is in the petition. And we clearly see that there is a nuisance claim for refusing to remove this old abandoned contaminated line. Your Honor, we don't believe this causes any damage to the property. I believe that once we get to this point, the plaintiff's own experts will admit as much. But we really need to clean up these pleadings. They are a shotgun approach at everything, and plaintiff simply lacks standing to bring any of those claims. Plaintiff's response states that that we don't understand what's in the petition, and they claimed that what happened was when we were replacing the line, we somehow disturbed the soil, and that caused all these problems. Well, there is absolutely no pleading of alleged negligence disturbance of or alleged negligent construction. No pleadings to support these allegations that they make in their response. They have pleaded claims of alleged damages that result from failing to pay for a second line and simply abandoning a second line. But they concede that, and this is on page 5 of their response, the plaintiff acknowledges that he only has standing to sue for injuries that occurred while he owned the property. And he has not alleged any competent evidence demonstrating that the abandoned line M caused damage to his property that is different from what was in existence at his time of purchase. So if we can go back one, Your Honor, I think they have conceded by that statement that we're entitled to a partial summary judgment on a lack of standing to bring the claims on the left side of your screen. Thank you, Your Honor.
All right. Mr. Artiago.
Thank you, Your Honor. Your Honor, I was hearing a lot of recitations of sort of factual arguments being made by the other side. I just wanted to narrow or more focus the presentation on what was actually in the motion, which was whether or not the plaintiff had standing to bring the claims that he brought. It's an interesting argument. They're not alleging, for example, under a no evidence standard that we didn't have evidence of causation or that we didn't have evidence of damages. And what they're arguing for is far more fundamental, which is, do we even have the right to allege these claims? Not do we have, do we lack evidence supporting these claims? That's for another day, as represented by counsel. So I guess what I'm struggling with, and perhaps what the response was struggling with, is understanding exactly the relief that was being sought by the other side in this motion, because at various points they seem to concede that we have standing to bring some claims, but not other claims. But it seems unsure to us exactly what do they mean by the claims that they say that we lack standing on. So if you look at the motion, they say you lack standing to bring any claims alleging damages related to line M. Well, Your Honor, that is not true. It also is somewhat mystifying why they would even make that argument. And the reason why we say that is because if Your Honor looks at the pleadings, our primary cause of action is a breach of contract claim, specifically alleging a breach of the easement. We don't disagree with the other side's characterization of the allegations that we're alleging that they breached the easement. But I think that is the primary issue that is in this case, and we have absolute standing to bring it. Your Honor, may I share screen, or is that functionality enabled?
Yes, sir, it's on.
Thank you. Let me share my screen just for a second. So what I'm showing, Your Honor, is the actual easement, which is a part of the pleadings in this case. And I just highlighted just the top portion. It says, we do hereby grant to T.J. Driscoll, his heirs and assigns, the right to lay gas pipeline for transportation of gas on and over through certain lands. What happened here, and I don't believe there's any dispute, is that they decided to replace the actual pipe. Now, there's a lot of argument about whether or not they replaced the pipeline. I believe that Atmos is taking the position that the pipeline needs to be understood as an abstract concept, that the actual physical pipe may change throughout time, but the pipeline itself stays the same. The reason why they've taken that position is because the easement below says that any additional pipeline could be installed, but additional consideration would have to be paid. So they've taken the position that they're allowed to simply replace the physical pipe. That does not change the pipeline. Regardless, Your Honor, what they've done is they essentially littered my client's property with an abandoned pipe. Our position is that when they did that, they are no longer in compliance with the easement. You can either put a pipe onto the property to actually transport gas through and over the property, or if you don't do that, then you don't have any right to be on that property, because ultimately the easement is still reserving all uses of the lands to my client, the plaintiff who owns it. So when Atmos came in and replaced the actual physical pipe and, quote, abandoned in place the old pipe, our allegation is that is a violation of the easement, and they're required to remove the old pipe because it is no longer compliant with the easement, and therefore they had no right to just simply leave it there in the land. The issue regarding the asbestos is not an issue of standing, it's just an issue of damages. They are arguing that, well, to the extent that the asbestos injured the land, that injury must have occurred at some time prior to you owning the land, therefore you should not be able to recover damages for that. I think that entirely misses the mark, because what we're ultimately seeking recovery for is simply the removal of that pipe and whatever cost it needs to remediate the land because of the removal. Because there's asbestos material that is associated with that pipe, that will likely incur, or at least include, some form of remediation, which is in fact, to my understanding, it's part of the summary judgment record, is what occurred regarding to this alleged ghost pipe. So, Your Honor, I guess what I'm mystified at is that clearly we have standing. Maybe Your Honor doesn't believe we have a case at the end of the day. Maybe a jury believes that we have not proven our case, but we have an absolute right to allege a breach of an easement. If we have the right to allege a breach of an easement, then all of the other actions, such as trespass and negligence, which are associated with these claims, we also have a right to bring those claims to. Your Honor, I don't want to belabor this fact. We have filed a substantial response which outlines all of the case law that specifically rebuts all of the argument made by opposing counsel. I would ask Your Honor, if Your Honor hasn't already read it, to read it, simply because the case law makes it very clear that if an injury or an alleged injury occurred during the time that a property owner owned the property, they're allowed to allege damages or allows causes of action that are flowing from that alleged injury. In this case, that's exactly what we have done here. The injury occurred when Atmos abandoned this asbestos-coated pipe on the property in violation of the easement. That is the central inquiry for a finder of fact to make. If we are right on that central inquiry, then of course we're alleging recovery of damages related to that asbestos pipe that was there in violation of the easement. Regardless if we have any merit bringing those claims, we have standing to assert it. And so we would ask Your Honor to deny the motion for summary judgment.
Thank you. Mr. McGuire, anything further?
Yes, Your Honor. That just completely missed the mark of what the purpose of this partial motion for summary judgment is. And I would refer Your Honor to the proposed order that we provided the court. Let me see if we can pull it up quickly. Your Honor, this is the proposed order. It's that Atmos Energy's motion for partial summary judgment on the sole issue of plaintiff standing is granted. Plaintiff's causes of action relating to any asbestos contamination on his property in existence prior to his purchase of the property in 2010 are dismissed with prejudice. That's the purpose of this motion. And we pointed out to Your Honor specifically the sections of the pleading that relates to. It relates to Section 36C. It relates to Section 43C and D. It relates to Section 48. So while the response, the oral argument addresses things totally unrelated to the subject of this motion about why the whole case shouldn't be thrown out, that's not why we're here today. We're here today in order to start narrowing down this shotgun pleading of all these claims that have no basis in fact or law, and this is the first of those.
Okay. Anything further?
As a reply, Your Honor,
Yes.
I would just add that I just wanted to highlight just how unusual the motion for summary judgment is. And I don't think I'm confusing it. I think the motion itself is confused. Generally, a motion for summary judgment is going to seek denial or granting or dismissal, of a cause of action. Sometimes it could be more narrow than that. However, what they're asking Your Honor to do is to pick between the various allegations and say, well, allegation number 25, that's no good, but allegation number 26 in the same cause of action somehow is still good. It just seems so very confused to me, particularly their proposed order when they're asking for a dismissal of claims related to line M. Well, that's the easement claim. That's the breach of contract claim that I spent so much time going over in the oral argument. That's pretty much 99% of this case is about line M in some form or fashion. I think trying to parse the claims in the way that counsel is asking Your Honor to do is simply not proper, and they're not entitled to it based off of the law as cited in our response. So, Your Honor, I would just ask that that you not sort of agree to the invitation being extended to you to parse through every single line item of this petition to decide which sentence has standing and which sentence does not. I don't believe that the summary judgment rules would allow for it. And at the end of the day, I do believe that we have standing to assert every allegation in that claim, even if some of those allegations turn out not to be meritorious.
All right. Is there anything further? I'm sorry.
Yes, Your Honor. Just quickly, it is a motion for summary judgment that is on our affirmative defense of standing. And the standing doesn't go to the whole case. It goes to part of the case. And if Your Honor will look at the proposed order granting the summary judgment, I think it's very clear that all of these things that he's talking about aren't even what we're asking for. They relate to our affirmative defense of lack of standing on the claims to which that is applicable.
All right, gentlemen, is there anything else for the court to hear today?
Yes, Your Honor, there are some special exceptions as well.
Okay. You may proceed.
First, Your Honor, a few days ago, there was a third amended petition that was filed purportedly to address some of our concerns. But all that did in the third amended petition is 2 months after the deadline to amend pleadings. As Your Honor is aware, we have a trial setting coming up. We've got expert designation deadlines today. We've got a discovery deadline coming up in a couple of weeks. And all they did by this third amended petition was remove some offending language on a cause of action that doesn't exist under Texas law and add a completely new cause of action. So the scheduling order in this case, which you see before you, requires leave of court for them to amend, which they did not seek before this. So whether it's under the second amended petition or third amended petition, there are still a number of things that we need to address here, but I guess we need to file a motion to strike this newly pleaded cause of action. It is not the subject of today's motion because it was just filed. But at any rate, Your Honor, the special exceptions go to paragraph 37, where there's this general allegation that the easement is ambiguous. Plaintiffs should be required to replead to include the language that they claim to be ambiguous. And Your Honor, there's a case on point that we have cited. It states that the meaning of the contract's term is not sufficient to create ambiguity. Contract is ambiguous only if susceptible to two reasonable meanings. And they have to plead that, and they have not in this instance. So if they're going to allege in this shotgun petition that has us chasing down hundreds of rabbit trails and would lead us to have a jury charge this thick, this is one that they clearly have to replead and tell us which ones are ambiguous. Your Honor, do you want to take these one at a time?
Yeah, but we can do that.
Okay. So, Your Honor, before I launch into a response, I just wanted to respond to the preamble of the argument. If Your Honor sustains any of these special exceptions, Your Honor would order us to replead to cure the pleading deficiencies. What we did when we filed our most recent pleading was we attempted to meet the special exceptions which were filed and remedy those alleged pleading deficiencies by simply filing an amended pleading. So this is not a motion for summary judgment. Your Honor is not here to dismiss any of these claims, just simply to order to replead. So I just want to make that clear because counsel is saying that we missed certain deadlines and therefore we're not allowed to replead, but that is the entire point of the special exceptions. So with that said, if we look at paragraph 37, 37 needs to be understood in context of the preceding paragraph, specifically 31 through 37 and 38. Those are the paragraphs under the breach of contract claim. And I already went through this with Your Honor on the breach of the easement issue in the motion for summary judgment. There's extensive allegations regarding what the easement requires, what it does not require. The easement is actually an attachment to the petition itself. And 37 is simply one of the many allegations saying that to the extent that the express words of the easement do not provide that the foregoing are breaches of the easement, then the easement is ambiguous and the foregoing accurately reflects the intent of the parties when entering the easement. That's what paragraph 37 says. And preceding 37 on paragraph 36 is a series, and it's on counsel's screen here, is a series of alleged breaches of the easement. Ultimately, the pleading standard in Texas is fair notice, and we believe that by specifically identifying what the alleged breaches are, providing the actual easement document itself as a part of the pleading, and then providing that to the extent that these breaches are not breaches of the express words of the easement, that was the intent of the parties, and there's an ambiguity that must be construed to conform to that intent of the parties, I think more than meets the fair notice standard in Texas. Not required to give extensive arguments and pleadings about what's ambiguous, what's not ambiguous, et cetera, which is essentially what that Texas Supreme Court case is talking about, which is what is sufficient to show ambiguity. We're simply required to make allegations that give fair notice of what our claims are. And we believe we met that standard, Your Honor.
Okay. Mr. McGuire.
Your Honor, I think it speaks for itself. They have not told us which words of the easement are ambiguous. They have not stated it in the pleading. They have not stated it in the written discovery. The plaintiff couldn't state it in his deposition. This is the problem with this case, Your Honor, is it's just this shotgun approach where we'll just throw everything there. We've been litigating this for over a year, and we still don't know what they claim to be ambiguous. There are no words, for example, on denying the full use and enjoyment of his land. That tells us nothing about which language in the easement is ambiguous, and the case law would require them to specifically plead that.
Mr. Artiago, on this first one, do you have anything further before we move on to the second one?
Yeah, I would just point out to Your Honor that the case law being cited to is not a special exceptions. They're not saying what is sufficient pleadings and not under the Texas pleading standard. So I guess I disagree with that. I do believe that the pleadings are sufficient, give sufficient notice to the other side. And I would just like to point out to Your Honor that even though the pleading has been characterized as a shotgun approach, there's only 3 causes of action: breach of contract, negligence, and trespass. That's it. This is not a shotgun pleading. It's extremely detailed and it gives fair notice of the claim. So I'd ask Your Honor to deny the special exception on that ground.
Okay. We'll go to the second one and last one, I guess.
There are actually a few, Your Honor.
My docket sheet shows 3 times 2. How many are there?
There are, let's see. There are 4 more, Your Honor.
Okay.
Paragraph 43E is this allegation that we somehow failed to comply with the rules and regulations adopted by the Railroad Commission. This is something that they do have to specifically claim, and that case is cited where plaintiff must be required to cite the specific rules. And this, again, Your Honor, this doesn't provide us fair notice. It would if they had any written discovery. If Mr. Ivy could describe it in his deposition, if their experts who have already been designated in this case came up with one, but nobody has cited any specific Railroad Commission of Texas rule that is even applicable to this case, much less that has been breached.
All right. Mr. Artiago?
Your Honor, we will agree to replead 43E to specify the specific rules. That is something we are agreeable to. It was an omission when I was drafting the amended petition to not do that. So we will agree to amend 43E to specify what rules we're referring to, excuse me.
Okay. Record can so reflect. Number 3, or the third one?
Yes, Your Honor. It's that nuisance is not a recognized cause of action under Texas law. A few days ago, they did remove this and put in a completely new cause of action in its place, which we will not try that by consent. It is a completely new cause of action that would cause us to have to go back and talk with our experts, possibly redepose the plaintiff. But this particular one has been within the last couple of days removed.
Okay.
Your Honor, I guess I disagree with that characterization. The title of the cause of action has changed. The cause of action itself, the allegations that are underlying it are the same. The reason for this is that in their special exceptions, counsel pointed out that under Texas Supreme Court law, relatively recent, in the last 5 or 6 years or so, the term nuisance is not to be understood as an independent cause of action, but simply a characterization of property damage. So someone, for example, could have experience a nuisance, if you will. Someone experiences a nuisance, they're really experiencing a type of property damage. However, the cause of action itself could be negligence in the case of a negligent nuisance, or it could be trespass in the case of an intentional nuisance. And so we read the special exceptions, we read the case law. While technical, it was valid. And so what we did is that we simply got rid of the term nuisance at the top of the cause of the action and inserted trespass, because that appropriately described the factual allegations that were subsequent to that pleading or subsequent to that heading. So the same allegations, same injuries, same everything. The only difference is that in response to their case law that they cited to, we struck out the word nuisance as the description of the cause of action and inserted trespass because according to that case law, that is the more appropriate and technically correct description of the claim. So they don't have to conduct any other discovery. They don't have to do anything. It is the same claim, same cause of action. We have simply struck out the term nuisance and put in trespass instead.
Your Honor, that's not before, this new cause of action is not before the court today. I don't believe that that was completely accurate, that that's all that's changed, but it's not before the court today, so I don't have it in front of me. I believe that, Your Honor, they need to seek leave of court for that to be addressed at all. And Your Honor, I'll be the first to tell you that if all of the elements of the cause of action are the same, if we don't really need any discovery, then I won't claim any harm or surprise. But I don't believe that to be the case, and it's not before the court today.
All right. You may proceed to the next one.
The next one is the failure, and this is paragraph 57 of the second amended petition. This gets down to the failure to specify the rights of these alleged damages, and that the damages that they are claiming here in paragraph 57 don't match up at all to what the remedies are available under their causes of action, and they are duplicative. For example, they're claiming lost profits from the sale of dirt off this property, but then they're also claiming, their expert claims that they're entitled to 100 cents on the dollar for the value of the entire 137 acres, plus a replacement property of equal value, plus the cost to remove the pipe. So these damages that they have alleged here, it's not a matter of they've given us fair notice. These aren't the damages that match up to the alleged causes of action. And Your Honor, you would think that that could be cured by request for disclosures. And in fact, Rule 194.2b4 specifically requires them to let us know how they calculate damages. They still haven't done it. They've, in response to requests for disclosures, they've recited verbatim paragraph 57. So there's no legal basis to recover these duplicative damages. And the reason we bring that to the court now, Your Honor, when we get down to a pretrial for this case with these far-flung allegations and these claims to all these damages, we're going to have a 100-page jury charge. Believe me, we started working on it. And so they should be required to replead and state the causes of action or the damages that are the remedies for the cause of action that they've pled.
All right, Mr. Artiaga.
Your Honor, the pleading standards in Texas don't require us to go cause of action by cause of action and to specify the specific damages we're seeking and quantify them or provide a method of calculation. Discovery may require us to do that. And to the extent that counsel is saying we have defaulted on our discovery obligations, then he needs to file a motion to compel, and we will have that hearing at that appropriate time and see whether or not we met our discovery obligations. But what counsel is arguing is whether or not we met our pleading allegations, and we are allowed to plead damages generally. In fact, the only allegations regarding damages that a plaintiff or a claimant is required to plead is, of course, the range of damages pursuant to Rule 47 and any special damages. And that's, in fact, that's the entire purpose of this section on damages, is to allege potential special damages because they do need to be in the pleadings. But besides alleging the existence of potential special damages, that's all we have to do, and that's what we've done. So to the extent counsel believes we're actually not entitled to recover some or all of these damages, That is a fact question. That's an issue to argue on summary judgment or at trial. It's not an issue for a special exceptions. So if he believes we're not entitled to some of these damages, then he's certainly entitled to file a motion for summary judgment or argue as such at trial. But I do not believe that special exceptions is appropriate here, because I believe counsel has been given fair notice. And I think that fair notice is proven by his arguments to Your Honor today, which is these damages are duplicitous according to counsel. These damages are not recoverable according to counsel. Well, the only reason why he can make that argument is because he's been given fair notice of exactly what the damages we're seeking and the causes of action that we've pled. So given the fact that counsel clearly has fair notice of the alleged damages, we'd ask that this special exception be denied as well.
Mr. McGuire, anything further on this one before we move to the last one?
Yes, Your Honor. I find it incredible that somebody could sit here and say, okay, what they need to do is come file a motion to compel, which I hate to waste the court's time and do stuff like that, but the gamesmanship here with these pleadings and with this discovery is such that if this is what we have to do, I mean, the record will reflect, he just said they should file a motion to compel. If that's what we need to do, first of all, I don't agree. I think that these have not been pled sufficiently, but if we need to come down and file a motion to compel and use up more of the court's time for that, then that's what we'll do.
Okay. And I think the last one, is that correct?
Yes, Your Honor.
You may proceed.
Paragraph 58 of the second amended petition is exemplary damages. And that's a special damage that must be supported by express allegations of willfulness, malice, or gross negligence to go beyond the allegations necessary in the petition seeking recovery of compensatory damages. Your Honor, the case we've cited there, the Parker Buick versus Tucci case, goes directly to that and talks about the pleadings requirements that are necessary. And I'm looking at page 129, actually page 130 of that document, that in order to plead an exemplary damages case, they need to tell us what it is that rises to the level of fraud and or gross negligence.
Mr. Arteaga, do you have a response? Sorry, there was a kind of a pause there.
No, I understand. I often run afoul of the Zoom technology. So, yeah. Your Honor, I would just simply point out, I don't believe that the case that counsel cited to actually does provide as detailed of a pleading requirement as perhaps being represented. I mean, I saw that the case was from 1990. I know that the addition or the statute regarding punitive exemplary damages was subsequent to 1990, which specifically only allows for the recovery of exemplary damages in the cases of fraud, willfulness, it's not willfulness conduct, usually malice, fraud, malice, and gross negligence. What we have done here is that we have specified the specific provisions of that statute that we're seeking to recover under, which is the fraud and or gross negligence. And by the way, Your Honor, the pleading standard in Texas, we've talked about the fair notice standard, but as part of that fair notice standard, you're allowed to make conclusory allegations. You're not required to get into specific factual and evidentiary matters in the pleadings themselves. So for example, while it's true, a plaintiff may be required to provide some additional factual details, either in the pleadings in the face of special exceptions or in the discovery, generally general allegations are sufficient. Here, we believe that we have been given very detailed allegations, factual allegations, specifically of the conduct on Atmos and why we believe it was wrongful. Now, I understand counsel doesn't agree that those allegations, even if true, would qualify as fraud or gross negligence. I understand that. But I think ultimately that is for a jury to decide or the fact finder to decide, assuming that summary judgment on those issues are not granted or sought. So, Your Honor, again, I just want to go back to my initial point, which is this is not a motion for summary judgment. Your Honor is not here to decide whether or not any of these claims have any merit. What Your Honor is here to simply decide is whether or not the other side has been given fair notice of the allegations, such fair notice that they're able to prepare a response and a defense at trial. I believe they have. Clearly, the arguments that I have heard have been evidentiary in nature. They've been factual. I believe counsel understands all of these allegations, doesn't believe all of them, obviously, but that's ultimately for a different day and a different forum. So again, I would ask Your Honor to deny the special exceptions. I believe they have been given fair notice of these claims and allow us to proceed with the case. Thank you.
Your Honor, let me read directly from the case because it was represented to you that I miscited it. It says damages are special damages that must be supported by express allegations of willfulness, malice, gross negligence that go beyond the allegations necessary in a petition seeking recovery of compensatory damages. So I don't think I miscited that case at all. And once again, Your Honor, here we are. He's representing to you that we have plenty of notice of what they are. Once again, there's nothing in their disclosure responses. So I suppose we could continue this gamesmanship, and we'll come back to the court with a motion to compel, and then come back to the court with a summary judgment on these things. Or, as I believe is required under Texas law, we can go ahead and replead with specificity.
All right. Anything further?
Your Honor, I would just point out that what was just read to Your Honor was regarding the issue of the need to expressly allege special damages, which I covered previously in these special exceptions. I agree, exemplary damages is a category of special damages which needs to be explicitly pled. And that's what we did. That's what we're doing by having the exemplary damages section and the damages section preceding it. We are alleging special damages because of the rules of civil procedure require it. But I think where the issue is not whether or not we need to allege it, because they have been alleged clearly. The issue is, do we need to get into specific evidentiary detail in those allegations? The fair notice standard in Texas does not require that. As long as they've been given fair notice, that is all that's required. So if they need additional allegations to be given fair notice, that's one thing, but that's not the argument. The argument here seems to be, well, we just don't like your allegations. Well, that's an issue for trial or for summary judgment. That's not an issue for a motion for special exceptions. They understand what these allegations are clearly, and they have an ability to prepare a defense, which they already have done and will continue to do. So again, we would ask that the special exceptions be denied.
All right. Both sides have given me quite a bit to consider. So is there anything further?
Not at this time, Your Honor.
No, Your Honor.
All right. That concludes this hearing. Thank you all.
Thank you.